Maayong buntag, buenos dias, and good day, Zamboanga region. I am Attorney Kerth Jossef M. Ablanque, currently designated OIC Chief Regional Adjudicator of the Human Settlements Adjudication Commission, Regional Adjudication Branch 9 nga nakabase diri sa Pagadian City. This month of October, we, our agency, together with the Department of Human Settlements and Urban Development and other key shelter agencies, celebrates the National Shelter Month. And as part of our continuing education, information, and communication drive, we will be uploading a series of videos in our Facebook account. And we hope that these videos will guide you about our agency, the HSAC, its mandate, its jurisdiction, rules of procedure, other important matters. So for this particular video, I will be discussing HSAC's mandate as well as its jurisdiction. The first is HSAC's mandate. In 2019, Republic Act 11201 was enacted. This law reconstituted HLURB into what is now known as the Human Settlements Adjudication Commission, or HSAC. HLURB's regulatory function was transferred to the Department of Human Settlement and Urban Development, while HLURB's adjudicatory function was transferred to HSAC. So basically, HSAC is a purely quasi-judicial agency. Sa mga walay idea, no, sa mga wala kabalo kung unsay pasabot sa quasi-judicial agency, ang Bisaya lang gid ani is murag korte. Unay pasabot sa quasi-judicial agency. So this is the mandate of HSAC. HSAC is a quasi-judicial agency tasked to adjudicate disputes relating to real estate developments, homeowners associations, and local and regional planning and zoning. Next is I will be discussing HSAC's jurisdiction. Again, sa mga wala kabaloan in jurisdiction, unsay pasabot sa jurisdiction. Jurisdiction is the power or authority to hear and decide a case. This is granted either by the Constitution or by a law. In HSAC's case, its jurisdiction over particular subject matters is granted by Republic Act 1120. Under this law, HSAC has exclusive and original jurisdiction over cases involving subdivisions, condominiums, memorial parks, and other similar real estate development, as well as cases involving homeowners associations and cases involving implementation of balanced housing development program, as well as cases involving laws and regulations implemented by the Department of Human Settlement and Urban Development. The two most popular cases or two most frequent cases filed before our office is what we call as are what we called as REM cases or real estate management cases and the HOA cases or the homeowners association cases. So before I will discuss what are those REM cases, allow me first to show you or to read to you the legal definition of what is a subdivision project, considering that the most common type of real estate development is, especially in Zamboanga region, is a subdivision project. So by definition, subdivision project refers to a tract or a parcel of land registered under 1920, otherwise known as the Property Registration Decree, or previously under Act Number 496, otherwise known as Land Registration Act, which is partitioned primarily for residential purposes into individual lots with or without improvements and offered to the public for sale in cash or installment terms. It shall include all residential, commercial, industrial, and recreational areas, as well as open spaces and other community in the project. So, as long as a real estate development is covered by this definition is considered as a subdivision project. So kindly please take note of that. So as I mentioned, one of the most frequent cases or most common cases filed before our office is a what we call as the real estate management cases or the REM cases. So under Republic Act 11201, there are at least seven types of REM cases. First are those actions concerning unsound real estate business practices filed by buyers or homeowners against the project owner or developer, which cause prejudice to the buyers or committed with bad faith and disregard of the buyer's rights. Please take note that there is no clear-cut definition of what constitutes an unsound real estate business practice. But based on the context of Republic Act 11201 and as well as PD 957, any act that prejudice or cause prejudice or committed with bad faith and disregard of the buyer's rights may constitute an unsound real estate business practice. So another type of REM cases are those actions involving claims for refund and other claims filed by subdivision lot or condominium unit buyer against the project owner, developer, dealer, broker, salesman. One of the most one instance that a subdivision lot buyer may claim for a refund uh, is contemplated under Section 23 of PD 957. Under Section PD 23 of PD 957, uh, this provision applies when there is a failure of the subdivision owner or developer to develop the subdivision project according to the approved plans and within the time limit complying with the same. So this is one instance where a subdivision lot buyer can claim for refund and file a case before. Another type of REM cases is are those actions involving specific performance of contractual and statutory obligations arising from the sale of the lot or unit and development of the subdivision or condominium projects. Again, one example uh, is an action compel the uh, compel the developer to deliver the title of the subdivision lot pursuant to Section 25 of P7. So this is one type of an action that can be considered as an action for specific performance, which can be filed before our office. Now, another REM cases are those actions or disputes involving open spaces or common areas and their use filed by the project owner or developer or the duly registered homeowners association, including eviction of formal settlers therein. So, uh, kani siya ng mga actions nag-involve siya ka ng mga informal settlers occupying the open spaces within a particular subdivision project or open spaces or parks, playgrounds, roads. Those are considered spaces common areas. So kung naay mga formal settlers occupy uh, the playground sa subdivision project, pwede ni siyang i-file sa amuang office. Now, other type of REM cases, uh, one is actions or suits to declare subdivision, condominium, or other real estate developments within the regulatory jurisdiction of the department or the DSUD as abandoned. Ka imong ipadeklara ang usa ka subdivision project as abandoned na. Abandoned subdivision or condominium project refers to a project whose development has not been completed in accordance with the approved development plan, despite despite the lapse of at least 10 years from the target date of completion, and it appears that the project owner or developer has no intention to complete the project development, or despite diligent effort for at least the last 5 years, the project owner or developer cannot be. So, kung ang usa ka subdivision project is covered by this definition, pwede siyang ipadeklara as abandoned. You can file it before our office. So another type of REM cases are those actions involving easements within or among subdivision projects. And the last one are those actions to annul mortgages executed in violation of Section 8957 filed by a subdivision lot or condominium unit buyer against the project owner and or developer. Kani siya nga provision, Section 8957, can be violated if the subdivision developer uh, mortgage a subdivision lot without the prior written approval of the appropriate government agency, and also without notifying the buyer of the subdivision lot of the loan value of the lot before the release of. So if Section 8957 is violated by the developer or the project owner, a subdivision lot buyer can file an action for. So these are the specific kinds of real estate management cases which our office has exclusive and original jurisdiction. So the next type of actions that I will be discussing, or types of cases that I will be discussing, uh, is uh, is what we call as HOA cases, or the homeowners association cases. HOA cases may involve controversies involving the registration and regulation of the homeowners associations, and may also involve intra-association disputes or controversies arising out of relations between and among members of the homeowners association, between any or all of them and the homeowners association which they are members. Inter-association disputes or controversies arising out of the relations between and among two or more homeowners associations, between and among federations and other umbrella organizations on matters pertaining to their exercise of their rights, duties, and functions. So please take note of the difference between intra-association disputes and association disputes. And again, the last type of HOA cases are those actions involving disputes between a homeowner association and the state, so far as it concerns their individual franchise or right exists, and those which are intrinsically connected with the regulation of homeowners associations or dealing with the interests of such entity. So these are the basic kinds of cases which our office has jurisdiction. So for further clarification and inquiries, feel free to contact us via email as shown in the screen, or through phone as shown in the screen. Thank you, everyone.